Good morning, everybody. It's Dave Neal, stand-up comic and host of the Rush Hour podcast, with an update in the Blake Lively, Justin Baldoni case. They just keep pouring in. Blake asks for more protection. This following a story we covered earlier where Blake says through sources that witnesses are staying anonymous because they're terrified of threats and bullying. Now, I can't speak for the internet because it is a pretty crazy place, but I've always said, if you have something to share in this court case, share it and just tell your truth. And I hope that most reasonable audience wouldn't come after anybody. Now, we live in a day and age where literally any psycho out there can make a death threat, and then when you receive the threat, you can go, see, look, there's all these threats against me. That's, first of all, we shouldn't be living in that type of world, and you should be able to find people that do make threats like that, because your First Amendment doesn't cover taunting other people with the, sanctity of life. So either way, here's the new article. Blake Lively asked judge for stronger protective order after receiving violent messages amid Justin Baldoni legal battle. So the question is, does this prove that there are other people that are willing to testify, or are they saying, hey, we couldn't get the people that were going to corroborate our story, and therefore it's because of the bullying and other things? And in fact, the people that they're talking about are Isabel and Jenny Slate, the two actresses, one that played the younger version of Blake Lively and the other that played Justin Baldoni's sister. And the sort of fake HR complaints that were floated around, which were never, validated by Sony, might have been made in their honor and maybe not by them. It could be that they were coerced into misremembering how things went down. And I could sound like a crazy person right now. Or it could be that they made those complaints, but they don't want to come forward for fear that it'll hurt their industry. I don't understand, because Blake Lively has WME by their side, the biggest agency in the world. So you would think if you have complaints that corroborate Blake Lively's side, that you would be rewarded with more films in that WME universe. Because how it works is, you might have a movie by a director who's represented by WME. They're going to try to cast that movie with as many actors from WME and a cinematographer and the PR people. It's called synergy, folks. So anyway, we're going to synergize right into this court case, and I want to thank our pal Lauren, who provided us with the documents. Again, you can go check out. Lauren covered this last night, just so you guys can go see, because we always like to check out. We like to support our friends here on YouTube. So here was her stream from last night. And again, she's almost at 10,000 subscribers. How exciting. Breaking: Blake Lively makes move against Justin Baldoni's alleged fixer. Was that the one from last night? Yeah, pretty wild stuff. So who's the fixer? We're going to find out. Pretty wild stuff right here. So I've got the court case. Let's get into it. Or I should say the document, 26 pages. Maybe we will skip through the boring part. There's some redundancies. But here is the letter to Judge Lehman from her lawyers. The court instructed the parties to submit a proposed protective order no later than March 11th, 2025. And if the parties are unable to reach agreement, to file competing versions by the same date with legal authority. All of the parties, including the plaintiffs in the Wayfair case, agree that a protective order is appropriate here and that the court should, at a minimum, enter its model protective order. Wayfair parties are amenable to the court's model protective order. Blake Lively, Ryan Reynolds, Leslie Sloan, and Vision PR, collectively moving parties, agree that good cause exists for the court to provide additional protections beyond those contemplated in the model PO by entering the proposed protective order attached here too as Exhibit B. The proposed protective order differs from this court's model PO primarily by adding the following: an attorney's eyes only category, AEO, which applies to confidential discovery material of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive, business, commercial, financial, personal, or privacy injury. So they're saying what we have to share with you is so personal and sensitive and of proprietary nature, and I have no idea what that means, that they want to make sure there's a protective order. Does that mean they're not going to share it publicly? Will it be, I'm honestly not sure. And people online are just saying, hey, we just want to know who's going to stand by these claims they're making. So they're limiting who can receive certain materials. And I guess that's, and again, I'm of the, look, I like full transparency, but if there's something that they want to share with the court that they don't think the public should see to protect people, that's okay with me if they all agree on it. It would be well within this court's discretion to provide the heightened degree of protection contemplated in proposed PO pursuant to Rule 26C of the Federal Rules of Civil Court. So they talk about all of the different requirements and share the case law. Good cause exists for the court to adopt the proposed PO, entirely foreseeable, probable, and inevitable that the release of certain discovery information, including of the type that the proposed PO specifies as deserving protection, will create a defined, specific, and serious injury to parties and non-parties, such as by violating their privacy, exposing them to threats, and creating a climate of possible witness intimidation. Those potential injuries, coupled with the threats to the efficient administration of justice, establish good cause to extend protections to specific categories of non-public private business and personal information. Here's what's crazy. When Blake released her, complaint and the New York Times article came out, everybody was ready to fry Justin Baldoni. Anybody who would have testified or spoken up in support of Blake Lively would have been championed. The majority of people were on her side. It wasn't until Justin Baldoni responded with very logical reactions to a lot of the claims against him that people said, maybe we're on the wrong side of this. And now Blake's side is saying, oh, see, look, this is super dangerous. We can't let these people out. They're going to get bullied and this and that. And it's like, well, everyone knows already who's involved. So either they decide on their own free will that they want to stand up for you or they don't. That will be telling. But hiding behind, we're going to get bullied. It's like, sure, trust me. Every single podcast episode I release comes with hate mail. You just can't please everybody. Look at the comment sections of my Instagram, folks. You can't please everybody. But with that said, credible, they should definitely take seriously any credible threats made against them. But, and again, I haven't seen them, but a lot of what times there'll be a comment from someone says, oh, I hope you die. And they'll say, oh, we're getting death threats. And it's like, first of all, back in the day, a death threat required a mailing address. They'd have to cut out the little magazine letters and send it. Now you just got a bunch of crazy, who knows how old they are. Could be some teen in his pajamas or some boomer in his, whatever. And you can just rattle off these things. Good cause exists for an AEO designation for highly confidential information of a personal, sensitive, or proprietary nature. So then they go on and discuss that. All right. Additionally, the Lively case rests in the allegations that the Wayfair plaintiffs launched and continued a retaliatory smear campaign in order to destroy and bury Miss Lively, funded by a defendant who committed $100 million to protect the studio like Israel protected itself from Hamas. There were 39,000 dead bodies. There will be 2 dead bodies when I'm done. Minimum, not dead, but you're dead to me. So that kind of dead, but dead to a lot of people. If they ever get me to that point, then I'll make it worth their while because I'm going to spend a lot of money to make sure the studio is protected regarding Lively and Reynolds. And again, this is what they claim Steve Sarowitz said. We covered this in the last video. Go check that out. We talked a lot about whether or not he would say that, what some sources from his religious group have said about him, how he would never talk that way. Either way, will somebody testify to say that they heard him talk like that? Because that's different than, hearsay, right? And also, is that a death threat? It looks bad on him, but when he says you're dead to me, so not that kind of dead, but dead to a lot of people. But when he clearly says 2 dead bodies when I'm done, minimum, not dead, but you're dead to me. So I know that's not great conversation, but I don't think that is a death threat. The court can, and by the way, however much money he has to fight this is like irrelevant. The court can minimize the probability of harm, oppression, or invasion of privacy by adopting an AEO designation that protects parties and third parties from delivering their most personal and sensitive materials directly to a group of individuals who are committed to weaponizing information at their disposal for use in a crisis communication combat plan. And again, I'm not sticking up for anyone making threats. I mean, that's ridiculous. The problem is are they going to conflate internet threats with, like, you could literally be lying under oath. I'm not saying they're doing this. You could be lying under oath and say, oh, the internet's going to bully me. Yeah, they're going to call you out on your bullshit. We call that consequences. But I don't think anyone should have to live in fear. So then they have the different exhibits. Respect to the lively parties, request for protective order. The Wayfair parties are amenable to the court's model protective order without the lively parties' proposed changes there too. And then it's just like the exhibits of kind of the different changes that they made, the different exhibits here for asking for protective order. In light of these acknowledgments, and based on the representations of the parties that discovery in this case will involve confidential documents or information the public disclosure of which will cause harm. How can they agree on this before knowing what the discovery is? It could be that they're trying to make it so that the public can't see the depositions, but everything they've accused him of is stuff that is already out in the open. That he left his arms on an actor's hips and was speaking wistfully to her under his breath, and he walked in on Blake breastfeeding. I mean, these aren't things that you would need a protective order for, right? So they say, hereby ordered that any person subject to this protective order, including without limitations the parties to this action, their representatives, agents, experts, and consultants, Taylor Swift, all third parties providing discovery in this order, and all other interested persons with actual or constructive notice of this protective order shall adhere to the following terms. So then they go through all of the discovery material, attorney's eyes only. And I personally think when I look at this is a chance to keep the public from talking about the dramatic and salacious aspects of the case. That's what I think this is. I think, and I know nothing about this, folks, but I think a judge might not want to issue like a blanket protective order and might say, I will look at the evidence and piecemeal which of it I think should be kept from the public. If there's some crazy case where there was like someone, died and there's, autopsy photos or a video and you don't want that out publicly, I can see that scenario where it's like, all right, fine. But a scenario where if you're suing someone for defamation, right? And again, they're both like cross suing each other for defamation amongst other things. If you're doing that, you would think that you would want as much information made public if you were on the side who was defamed. So if all these accusations were made up and Justin is innocent, you don't want to just win in court. You're trying to win in court, but present that evidence to the audience, present those depositions. So I don't know what they're thinking would entail a protective order. We'll get a response by Brian Friedman. My guess is, power attorney for Justin Baldoni, he's going to say something like, this is ridiculous. She made these claims publicly, and he's allowed to defend himself in front of the public eye. That's my guess. With respect to deposition transcripts, a producing person or that person's counsel may designate such portion as confidential or attorney's eyes only, either by A, indicating on the record during the deposition that a question calls for confidential discovery information, in which case the reporter will bind the transcript of the designated testimony. So that's kind of like what I was saying. They can, as they're doing the deposition, they can, if there's something so personal to somebody that they don't want out there and it's irrelevant maybe to, I don't know, the meat and potatoes of the case, maybe they can on the moment say, hey, can we just keep that out there? No person subject to this protective order other than the producing person shall disclose any of the discovery material designated by the producing person as confidential to any other person involved, except to the parties of the action. So yeah, I mean, look, these depositions have a way of leaking themselves. Stenographers engaging to transcribe depositions conducted. So it basically just says who's going to be allowed to share this and who's not. And again, boy, it's kind of like the Barbra Streisand effect. It's like, well, what is so secretive that they don't want shared? I honestly can't imagine, because, we just haven't seen anything in the court documents so far that I think would warrant confidentiality, right? Leave a comment. Let me know what you guys think. So then we have, the signatures, and then the next exhibit is another protective order, and then it's just kind of got the red lines through it, like what they agree to, what they don't agree to, just kind of crossing their T's and dotting their I's. I don't think there's anything too juicy in these final exhibits. And I'll just say this because, sometimes the internet will willfully mischaracterize what you're saying. So I want to double down on this right now. I don't think anybody online should ever DM or send messages to or threaten in any way anybody testifying, because then the other side gets to see, my witnesses don't even want to show up. They're afraid because the audience is so ravenous. I can't speak for other people, but I hope that my audience is watching this play out with the same respect and grace that I think I am. And that's what we need here. We need to say, hey, a lot of people believe Justin Baldoni right now, but we got to get to the trial if they decide to do that, so Blake and whoever her witnesses are can testify and put together a fair case. The case has to be fair. When that's all said and done, you can decide to believe Justin. You can decide to believe Justin now. That's not illegal. But again, sadly, cases like this attract cuckoo people. Covering the Clayton Echard case, even a much smaller case, it attracted insane people. I was covering someone who was faking a pregnancy. I was also, she was suing me for harassment. The day I settled that, which means she had some bizarre thing where she wanted me to say I would never, I would never encourage anyone to hurt her, which I never did in the first place, of course. Come on, you guys know me. But on the same day, she received a death threat. And that was supposed to be because, I'm getting death threats here. And it's like, first of all, the threat could have been coming from inside the house. We have no idea. But the point is you have to kind of operate in an environment where this all plays out. You can decide not to go watch any of her movies again. I would say the best thing you can do is vote with your dollar. Decide not to support people if you don't agree with them. And if Baldoni is found to be guilty, if the testimony happens and it's pretty damning and there's information we don't know about, then you can decide not to support him. And he'll probably have to go, I don't know, get a job as a carpenter or a deckhand or whatever the heck you do when you don't make it in Hollywood. A YouTuber. But he'll get a new podcast, whatever. Everyone who gets canceled just starts a podcast. But anyway, those are the options. Violence, not one of them. We'll see how this plays out. And I'm not scolding anybody. I haven't seen anything in my comment section in any way whatsoever that would make them feel that way. And hopefully the moderators and the YouTube guidelines will just reject those types of comments anyway. But hey, I'm not saying they don't exist. And get the protection, get the witnesses. We want to hear from everybody. Credibility's on the line. More content coming your way right after this.